Newspaper reports suggest that Kanye West and Adidas have parted company, but what has happened? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel, like this video, and keep the conversation going in the comments section as well. So I'm joined today by Lucy Marlow. Lucy is a senior associate solicitor within JMW's intellectual property department. So Lucy, what's happened between Adidas and Kanye West?
Well, Adidas and Kanye West were collaborating where Kanye West's branding, Yeezy, were applied to a range of shoes that Adidas had brought to the market. But given the controversy that surrounded Kanye West, Adidas have decided to bring that partnership to an end.
And I see a lot of these celebrity endorsements, if you want to call it that. You know, can manufacturers, can brands get out of these agreements?
Well, the answer to that really lies in the contract and what the termination rights are in that contract. I assume in this case that Adidas do have the rights, because if they terminate where those rights aren't available, arguably they could be on the back foot of a claim for wrongful termination and repudiatory breach.
And as I'm talking to you, Lucy, I've got visions in my mind of a warehouse somewhere with a stock of shoes. I mean, if that is the case, can Adidas continue to sell them?
Well, the answer to that question all lies in the IP that subsists in the shoes. And as in most products, there's a whole range of IP rights at play. You've got copyright, design rights, maybe even patents, branding. Now, in this particular case, Kanye West owns several trademarks, one of which Yeezy. So what this means is that in order to continue with that stock, Adidas will need to remove the Yeezy branding to avoid a trademark infringement claim being brought by Kanye West.
And I know that you're an intellectual property specialist, Lucy. Kanye West has a patent in these. What does that actually mean?
So it looks, from looking at the intellectual property register, that Kanye West owns a patent for the Yeezy slider shoe. And what that patent will cover is, you know, the technology, presumably, that lies in that particular model of shoe. And as a result of that, Adidas will not be able to supply to the market shoes that embody that technology, as otherwise they would be, again, on the hook of a potential patent infringement claim.
And so how can you more generally help clients who have a particular issue in this sort of area?
Well, this case in itself brings to light the point of the commercials that surround these collaborations. They can be hugely successful and profitable. In this case, the royalty costs for Adidas were in the region of £300 million. But this deal created $2 billion worth of sales. So it was a very profitable collaboration. But an interesting takeaway point is that if a business is thinking of entering into a collaboration, maybe a brand ambassador relationship with a celebrity or a sports star, both parties need to think about their intellectual property position and ensure that those rights are secure. So, for example, Kanye West, it was important that it had secured its trademarks, as these trademarks were licensed to Adidas in order for Adidas to apply them to their particular project range in exchange for the royalty fees. And this is something that we regularly advise our clients on.
Lucy, thank you for your insight. And if you'd like to contact Lucy, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.